declare the motion passed. Members' motion with no legislative effect. Dr. Nguyen Yu will move a motion on improving the policies on foreign domestic helpers. 2 members will move amendments to the motion. This council will proceed to a joint debate on the motion and the amendments. Later, I will first call upon Dr. Nguyen Yu to speak and move the motion. Then I will call upon Mr. Chun-keung and Ms. Judy to speak in sequence, but they may not move the amendments at this stage. The joint debate now begins. Members who wish to speak, please press the request to speak button. I now call upon Dr. Nguyen Yu to speak and move the motion. Thank you, Mr. President. Now, in relation to the policies on foreign domestic helpers, we had another debate last year. The original motion with amendments were passed. Why is it that 1 year on, this year, I'm moving a similar motion? Why do I persist? That's because a year on, we haven't seen any improvement in government policies. We are disappointed. In the 70s, some 20,000 foreign domestic helpers worked in Hong Kong, but in a recent peak, we have some 400,000 foreign domestic helpers in Hong Kong. Let's say for 1 in 3 households, there is 1 foreign domestic helper. We're talking about 1/3 of a population having a foreign domestic helper at home. It's a livelihood issue, and this is pain in the neck for many. As I do community work, I very often receive inquiries from members of the public. They air grievances and lodge complaints. And in fact, the Consumer Council on a yearly basis published the 10 top news relating to consumers, and the foreign domestic helper issue hit the headline again this year. So it's a common problem facing many people. In light of the situation in 2021-2022, we conducted surveys in 2 consecutive years, and we collected views from 1,600 employers. In October 2021, the Family Committee of the DAB also held a meeting to conduct an in-depth analysis of the issue of foreign domestic helpers. There are 3 major issues. First, a mismatch. Basically, it's like a blind or arranged marriage. In fact, last month, in the TV program Scoop, some employers tried to find a foreign domestic helper who would be meticulous and who would work hard. But after the foreign domestic helper had arrived, the helper refused to cook for the family. She even used a knife to threaten the family members. So despite paying medical expenses for the physical checkup of the foreign domestic helper, the family in the end lost the help. So it was a pain in the neck. Next, unscrupulous intermediaries. Many employment agencies provide a schedule of fees, but according to our survey, slightly over 50% of employers said that they encountered EAs with a clear schedule of fees. Some 30% of employers said they did not have a schedule of fees. And during the epidemic, there was a shortage of foreign domestic helpers. This is still fresh in our minds. Many employers were aggrieved. On arrival, the foreign domestic helpers were required to live in a quarantine hotel, not to mention other miscellaneous fees. And the employers paid some $20,000 extra to the employment agency. But in the end, despite paying that hefty sum, the foreign domestic helper did not arrive after 2 years. And the third problem is that in terms of the government's policies on foreign domestic helpers, the government departments work in silo. And if you have a question to ask, you don't know which department to go for. You don't know whether you should go to the Immigration Department, Labor Department, or the Consumer Council. Last year, we made this submission to the Chief Executive. We advocated on improvement measures on foreign domestic helper policies. There are 13 recommendations. I think the government should start with the easiest ones and improve the policies. The more difficult ones include improving the standard employment contract and addressing the ambiguities. For example, some foreign domestic helpers are eventually found to be medically unfit for work after the contract has been signed. The problem is that the standard employment contract only stipulates that the foreign domestic helpers should be fit for work, and a lot of details are missing. In order to address the ambiguities, now there should be a clear definition on medically fit for work. For example, the items of the medical examination should be clearly spelled out in the contract. There are also other ambiguous clauses in the contract. For example, when should or under what circumstances should an employer be responsible for the return passage to and from their home countries, and whether it is possible to pay the help in lieu of the statutory leave. Many employers are unclear about these details. Perhaps an attachment should be drawn up for the purpose of clearing the ambiguities. As for other matters such as charging excessive commission by EAs, the Code of Practice for Employment Agencies should be revised so that medical examination and fees for passage, etc., should be included in the contract, and in the service agreement, the payment arrangement terms should also be made out clearly, together with refund arrangements, and a standard form should be adopted for easy compliance by the EAs. Different government departments are responsible in a fragmented manner for foreign domestic helpers, and members of the public are unsure whom to turn to. The government should make reference to the Property Management Authority and the Tourism Industry Authority by setting up an FDH authority so that the centralized approach can be taken on licensing and regulatory matters. A committee should be set up comprising employee representatives, FDH unions, so on and so forth, so that if need be, the committee can help disseminate messages and discuss relevant matters. In the past 2 years, because of the epidemic, the government made changes to the FDH policies. Many EAs were ignorant about the changes. The government should make sure that messages are disseminated in a timely manner and in a clear manner to avoid misunderstanding. I hope that this term of government will listen to the voice of the people and start preparing for the establishment of an FDH authority and draw up long-term policies on foreign domestic helpers. I move that the motion as printed on the agenda be passed. I now propose a question to you that Dr. NGAN Men's motion be passed. Mr. Lee Chun-keung.
Thank you, President. In this chamber, we have discussed issues and topics related to FDH time and again. It goes to show that the policies are far from satisfactory. Let me tell you a sad story of an FDH employer. Well, very often an employer would rely on the service of the agency, and many problems can arise out of their employment of FDH. My fellow Liberal Party member, Mr. Frank Mr. Yik Chi-ming will talk about other issues. Well, actually, there's a shortage of FDH, and therefore the FDH who terminate their contracts prematurely are in great demand. But the government has no support service for employers. They are not instructed on how to find a good FDH. And we don't know whether an agency is a license or just an intermediary for another agency. They rely on a word-of-mouth recommendation of friends and relatives. Therefore, these agencies are unruly and difficult to control. Many families have told me that before they see the FDH, they will have to pay tens of thousands of dollars in agency fee. And the fees and charges are not transparent. And many employers don't know what those fees and charges are for. And they have to wait for up to 9 months before they actually have the FDH coming to Hong Kong. And they have to reimburse a lot of fees and expenditures such as traveling and etc., traveling expenses, etc. If they don't pay up, they will not get the FDH. And if they discontinue with the process of employment, the fees will not be repaid. And our system encourages FDH to terminate their contracts prematurely so that they can work for another employer and get a higher income. So these employers are at a loss as to what to do. The government should ensure that the agencies should follow all the employment agencies' regulations and set up a foreign domestic helper licensing and a merit point system. There should be a website with a blacklist of job hopping FDH, and also more importantly, the fees and charges of agencies should be made public. With the shortage of FDH, many unscrupulous agencies have seized the opportunity to make a bigger gain, bigger profit. They would market their FDH as very good and quality FDH, saying that they are very skillful and very presentable. But the employers can only rely on the 10-minute video conferencing material to understand what the FDH would perform. They don't know whether they are telling the truth or lies. They can only rely on the CVs provided by the agency, but they are not certain about the truthfulness of the information. Therefore, I think the government should set up a skills testing center for FDH so that they should go through testing household techniques and skill tests before employment. If the FDH cannot reach a certain standard of skills, the agencies should be required to provide training. Actually, this is just a very simple and modest request from the employers. They want the FDH to comply with the contract in substance and in spirit, and they would work for 2 years. But now it's very difficult to see this realized. It's actually, to many of them, a pipe dream. The government, once again, I would like to urge the government to make sure that the agencies comply with the regulations, and also to ensure the interests enjoyed by the employers under the legislation are protected. I hope members will support my amendment. Miss Judy Chan. First of all, I'd like to thank Mr. Ngan Yu for moving this motion on improving the policies on FDH. Topics surrounding FDH have been discussed many times in this chamber, but the government policies on the same have not been improved. They have been the same for years. As a result, there are many unscrupulous agencies and misbehaving FDH affecting the interests of their employers. With an aging society, we are relying more and more on FDH to care for our children and our elderly family members. We have to make sure that the Hong Kong families should have the ease of mind in employing FDH so that more of our citizens can join the workforce. We have a workforce of FDH numbered more than 400,000, and in recent years the number has dropped a bit because of the epidemic, and now epidemic is a thing of the passed and we are on the path of recovery, many families will require FDH, and the number will go up once again, I'm sure. So it's time to improve and update our FDH policies. Over the years, the agencies made use of some gray area in our regulation, and as a result, the aggrieved families have nowhere to turn to for their difficulties. Some FDH would do job hopping. Some would not do their job properly, and some even resign to get a better job, so that their employers may have to resign as a result, so that their family members can be cared for. Although we don't have any regulation about job hopping, and the unscrupulous agencies are not properly monitored and regulated. So we don't have a healthy environment in the employment of FDH. And it would affect the attractiveness of Hong Kong as a destination for FDH. If we cannot attract FDH to come to work in Hong Kong, the families which require their services will be affected. At present, we have the so-called standard contract approach. The model contract has been in use for decades, and unscrupulous agencies would incite FDH to make use of the loopholes for better gain. I'm very disappointed by the inaction of the government so far. At present, both the FDH and the employers are losing out in terms of their interests, affecting hundreds of thousands of families and FDH. We are in a vicious cycle. We have to better protect the interests on both sides. Measures should be taken. There should be a better platform to provide support for employers and FDH, and we should improve the legislation and regulations, and also to raise the threshold of entry for employment agencies, and to whip out irregularities and malpractices, so that we can enhance the service quality of agencies. With these remarks, I hope members can support my amendment.
Secretary for Labour and Welfare. Madam Deputy, I'm grateful to Dr. N for moving the motion, as well as Mr. Lee Chun-keung and Ms. Judy Chen for proposing the amendments, so that we can better understand members' views. At the same time, I get the opportunity to talk about the government's policies on foreign domestic helpers, as well as our work in protecting the interests of FDH, the employers, regulating the employment agencies, and combating against job hopping on the part of foreign domestic helpers. As a result of the lack of full-time live-in domestic helpers since the 1970s, we gave permission to import foreign domestic helpers to come to Hong Kong to work. Both FDH and local employees enjoy the same labor rights and protection. And we have also promulgated the standard employment contracts for FDHs so as to protect the interests of both the employer as well as the employee. Foreign domestic helpers have played a very important supporting role, and they take up the duties of house chores, and they take care of the young as well as the elderly members of our families. We have been making sure that foreign domestic helpers could come to Hong Kong to work, and the employers will be given reasonable protection, and have been reviewing the policies and the measures as well as the standard employment contracts. Currently, there are 340,000 foreign domestic helpers providing service to our local families. In the past, all our departments have been cooperating closely and providing support to both the FDHs as well as the employers. In order to have better coordination and liaison among government departments involved, in the year 2020, the Labour Department set up the FDH division so as to ensure that there will be effective coordination and there will be an
enhancement in our protection measures and provide better support to employers as well as the foreign domestic helpers. And we have set up a 24-hour hotline, 2157-9537, with interpretation service for a number of languages. During the 2019 COVID pandemic, the division has played its role actively, and we have been having seamless cooperation with government departments. We came up with measures and policies to help employers and FDH to cope with the pandemic, like having facilitation measures together with the immigration department, so that with the consent of both the FDH and the employer, there can be an extension of the contract and there can be a deferral of the return passage to the place of origin. And we have been taking the problem of job hopping seriously. And we've been working together with the Department of Health, the employment agencies, and the Consulates General to allow FDH to come back to Hong Kong orderly. And we make arrangements for quarantine facilities for the FDH. It shows that the existing mechanism is effective, and departments can play the role effectively according to their own portfolios, and we can react very swiftly. We are concerned about the professionalism as well as the service quality of the employment agencies. We issue licenses, we inspect, we investigate, and we prosecute the offending employment agencies. There's a dedicated website to provide information related. We don't just regulate the licensees. We also cover the management as well as the employees. When we deal with a license application, other than looking at the records of the licensees, we also look at the records concerning the operators, the management, as well as the employees, to check if they have been breaking the law or the code of practice of the employment agency's COP. If so, then the application for license will be rejected. There are more than 40 detailed requirements under the COP. All the practitioners must comply with them, otherwise the license may be revoked. The licensee, the nominated operator, the management, as well as the employees must have a reasonable knowledge of the relevant laws and regulations. Employment agencies responsible for providing service to FDH must be familiar with the standard employment contract as well as all the FDH-related documents. The COP also requires that the licensee, the company director, the nominated operator, as well as the senior management must closely supervise their staff members and must be responsible for the acts and conducts of all their staff members. Regularly, the Labor Department provides briefing sessions for employment agencies to make sure that the practitioners will be aware of the laws as well as the requirements under the COP. In the past 5 years, that is between 2018 and 2022, the Labor Department inspected employment agencies for nearly 7,000 times. Successfully, we prosecuted 39 employment agencies for overcharging commission or being an unlicensed operation, among other serious offenses. And they have also been having their licenses revoked, or we refuse to issue license or refuse to renew the license. There are also 28 other employment agencies that have breached the code of practice, or they have malpractices, and then they have their licenses revoked or not renewed or not issued. Say, for example, not having service agreements signed with FDH or employers, or failing to set out the items of payment, or failing to get confirmation from the employers concerning the briefing on the rights and obligations, failing to keep records of the dealings. And in fact, many of them would cover acts and conduct of their employees. It shows that the existing system provides adequate supervision and regulation of the practitioners. And for such law-breaking practitioners, their employment agencies cannot continue with their business. During the pandemic, there was a large number of FDH not able to come to Hong Kong to work, so there was serious job hopping. The Immigration Department and Labor Department have been working hard on this matter. there is a special duties team of the Immigration Department who will consider whether there's evidence to show that there's job hopping, like the number of premature termination of contracts and reasons. And in fact, in the year 2021, 2,833 cases of visa application have been rejected because of suspicion of job hopping, 9 times more than that in 2020. And we keep records of refusal so as to form the grounds for making decisions on the subsequent visa application or application for extension of stay. The Labor Department has been dealing with employment agencies that abate ethics in job hopping. Like we look at their business practices, and we also go to visit those EAs that provide cash incentives to ethics or their referees. And we have been sending out letters to the EAs to alert them not to use business practices to incentivize or abate job hopping on the part of ethics. The Labor Department and the Immigration Department mounted joint operations. We inspected those suspicious enterprises. For the past 3 years, that is between 2020 and 2022, the Labor Department carried out 186 spot checks upon complaints, and we also issued 600 advice to 195 EAs, and they have been warned not to engage in job hopping. And we have also understood that they have already stopped providing cash incentives. With the easing of the pandemic in the second half of the year, and with more FDH coming back to Hong Kong to work, and with our inspection and vetting work, job hopping has eased. We received 47 complaints, 70% less than 177 received in 2021. And we have a small number of refusal of visa application, down to 1,760 in relation to the Immigration Department's work. Now, for skills and training, according to the existing policies, before they come to Hong Kong, FDH must have at least 2 years domestic helper experience before they come. And for their place of origin, they would also impose requirements on training and assessment. The Director of Social Welfare has been launching a pilot scheme on training for FDH in elderly care so as to hone their skills on taking care of the elderly. We also provide talks covering occupational safety as well. Over borrowing on the part of FDH would cause concerns, and employers mustn't be affected as a result. Under the Moneylenders Ordinance, the statutory interest rate has been adjusted downwards, and the code of practice doesn't allow EAs in getting involved in the financial dealings of the job seekers. We'll continue to work with the NGOs to make sure that they understand the need to be prudent about the financial arrangements. So I spoke. Thank you.
Mr. Chan Siu-hong, I would like to thank Mr. NGAN for moving this motion on the HDH policies, and also the 2 other members who have moved their amendments. Many people in Hong Kong have employ FHD so that both husband and wife can go out to work. According to CNS Department, as at the third quarter of 2022, we have 333,000 FDH, or 8.8% of the total workforce in Hong Kong, providing the necessary service to many families. They are very important in Hong Kong. Some of them are part of the greater families included in the employer's home. But many agencies are providing substandard services. Many unscrupulous ones are providing very poor service, especially during the epidemic. Because of the measures to fight the epidemic, the employers had to pay for a lot of expenses, including the COVID test services and the quarantine hotel charges. So a lot of money is paid before the FDH arrives to serve. But many agencies would persuade and incite FDH to quit prematurely. And many families suffered, and they may have to resign from their jobs to take care of family members instead. We have 344 cases of employment agencies violating the code of practice or the regulations. So I'm more in favor of stepping up the regulations. There should be a license systems for the agencies, and so that their service can be improved, and so as to better protect the interests of FDH and their employers. The FDH Division of the Labor Department is responsible for enforcing the law. They will carry out inspections and initiate prosecutions. They have to make sure that the agencies are delivering their service in accordance with the law. Members would understand how many agencies have been warned or have their licenses revoked. But there's only the distinction between lawful and unlawful activities. This is not sufficient. We should learn from Singapore. In 2011, the Singaporean government introduced a legal framework to regulate the work of the employment agencies. There's a scoring system on their service levels. And citizens in Singapore can access the scores and the rankings of EAs in the countries, and they also they can also access wage rate, termination of contract rates, etc. And all the employment agencies have to undergo a 30-hour training course before they can be licensed. In Hong Kong, we have a problem with FDH taking out loans and then subsequently unable to repay. They borrow from banks or finance companies, and they may just leave Hong Kong. Therefore, there are many cases of nuisance caused by the debt collection agencies when they go to the homes of their employer for debt collection. We should ask banks and finance companies to submit information of borrowing to the regulatory authority, and so that we can have information on the length of their service contract period, and banks should have access to such information before deciding on whether to grant a loan. We should improve the regulation system. So I submit.
Ms. Nixie Lam. Thank you, Deputy. I speak in support of Dr. Ngan's motion and Mr. Lee's amendment. There are 350,000 foreign domestic helpers in Hong Kong, some 8% of our working force. They play a pivotal role in supporting our families in Hong Kong and allow more women to join the workforce and contribute to the economy. With an aging population and low birth rate, Hong Kong is faced with a major problem. In light of the aging society, it is expected that there will be a keener demand for foreign domestic helpers. We've heard about various complaints relating to foreign domestic helpers and the employment agencies, and there have always been heated debates in society. Basically, the government attaches or abides by the policies drawn up in the 1970s, but they are now outdated. The government should comprehensively review policies on foreign domestic helpers to enhance the statutory rights of both employers and helpers. Now, different government departments are responsible for FDH. Say, For the Labor Welfare Bureau and the Security Bureau, they are responsible for policy matters, and the Consumer Council and the Immigration Department are responsible for operational matters. The government should make reference to the authority set up to regulate other industries, such as the tourism industry authority, to establish a similar authority to vet the license for EAs and FDH applications. The authority should also regulate other matters such as the dormitories for FDH inspections, training, so that a one-stop portal can be provided to deal with all the various issues relating to FDH. The existing provisions are quite vague. I mean, the clauses in the employment contract, for example, there are ambiguities in the medical examination items to be covered for an FDH to come to Hong Kong. This will cause employees to suffer a loss. The government should review the standard employment contract so as to clear the address the ambiguities in the medical examination requirements for FDH. Clear provisions should be included in the standard employment contract and improve the requirement for FDH to return to their place of origin after the end of the contract. The minimum allowable wage at the moment is $4,730, but because of the epidemic, there is a demand-supply imbalance, and employers have had to pay a hefty sum in order to get an FDH. This poses a great financial burden on employers. In light of the escalating costs, the government should provide new tax breaks, such as the fees for medical examination for newly arrived FDH, training fees, and also other relevant expenses to alleviate the financial burden on employers who employ FDHs. This relates not only to the well-being of some 400,000 households in Hong Kong. It also relates to the policies on foreign domestic helpers as a whole. The government should improve the relevant policies and safeguards the rights and interests of both employers and helpers. Dr. Chun-keung. According to the Immigration Department, as of the end of 2021, some 339,000 foreign domestic helpers working in Hong Kong. They accounted for about 1% of the population and covering some 10% of all households in Hong Kong. They provide services to take care of the young and the old in the households and allow more women to join the workforce. So they are contributing force to economic development in Hong Kong. And according to the Census and Statistics Department, in the FDH sending countries, some 6.7% of their population come to work in Hong Kong. So they make a contribution to our economy. But there are also concerns on, for example, the regulation of employment agencies and foreign domestic helpers. And in fact, in 2019, there were 339,000 FDH in Hong Kong. In 2021, it was there were about 340,000 FDH in Hong Kong, a drop of 15%. So the government should tap new sources apart from the usual FDH sending countries. With fewer FDH in Hong Kong, more people would have to take care of their families, and more women, therefore, would not be able to rejoin the workforce, especially for grassroots positions. The vacancies are not filled. This will have far-reaching implications on the local economy. The government should start negotiations with importing foreign domestic helpers from Myanmar and Cambodia. They are more friendly, and in 2021, in an aging society in Hong Kong, 1/5 of the workforce 1/5 of the population is age 65 or above. It will soon become 1/3, and there are some 300,000 households indicating they wish to hire a foreign domestic helper to take care of the elderly members. So it is envisaged that more foreign domestic helpers will be needed to take care of the elderly. In light of the aging population, the government should improve the quality of foreign domestic helpers in Hong Kong for the benefit of Hong Kong people. Mandatory short-term training courses should be set up, and more FDHs arriving in Hong Kong should take these courses, and there should also be dedicated training courses for caring for the elderly, and there should also be Cantonese courses. The employment ordinance and the employment agency regulations are the regulate the employment agencies. There are still many problems. In order to protect the interests of employers, the government should step up their effort. In fact, in recent years, the Indonesian and the Filipino governments have stepped up the requirements by increasing the fees for visa, and the commission could be as high as $20,000 to $30,000 for EAs. It is unbelievable. Many FDH employees in Hong Kong are also the working population, so they have a lot on their shoulders. And many EAs are unscrupulous. For example, they set up different expense items such as photocopying fees, etc., to fleece employers and extort an exorbitant commission. I support Dr. Yemen Yu's motion and Mr. Lee's amendment. The government should improve the policies on foreign domestic helpers. It is time to do so. The government can take a proactive action in intervening and conducting investigation. In light of the possible domination of the EA industry by some, the government should make clear should require that expense items be clearly set out, and in unscrupulous circumstances, the government should also take enforcement action to protect the interests of employers. The EA regulations should also be reviewed so as the code of practice for employment agencies. The government should consider removing obsolete provisions and those that would hamper the interests of employers. We should revamp them as quickly as possible so that it will be costlier for the non-compliant EAs to operate. Mr. Lai Tong Kwok, I support Dr. Yemen Yu's motion and Ms. Judy Chan's amendment. As we all know, there is a keen demand for foreign domestic helpers in Hong Kong. Against the backdrop of an aging society and low birth rate, more FDHs will be needed. It is not easy, however, to maintain a stable supply of foreign domestic helpers. This is not an issue unique in Hong Kong. We also face competition from Singapore and Dubai. These are neighboring places, and according to some, foreign domestic helpers, after arriving in Hong Kong, will look for further opportunities overseas. And in light of the fierce competition, we must improve the policies on foreign domestic helpers in order to benefit not only employers but also the households with foreign domestic helpers. The original motion has mentioned this point, and also the amendments. That is the thematic website for foreign domestic helpers. More information on EAs should be provided. This is a good suggestion. It is a fact that the EAs are of different or perform differently. At the moment, the Labor Department provides a thematic website, and prospective employers can look for an EA on the website, but there is more to be desired. For example, this is an integrated website for EAs, and we have EAs for FDH, EAs for local domestic helpers, for clerical work, etc. Because of the keen demand for foreign domestic helpers, there should be a dedicated website for FDH EAs Second, the government should consolidate the available information. For example, on different websites, there are blacklists of EAs committing overcharging of commission, and they are on the blacklist. And there should be a list of EAs, the licenses of which have been revoked, and along with other lists. However, the government should have walked the extra mile. When somebody wishes to look for an employment agency, one would rarely turn to these blacklists to check whether the EA is on any of the blacklists. They are scattered on the website. It is not user-friendly. The government has not consolidated the useful information. Third point, not many useful information is provided on the website. More should be done. For example, number of foreign domestic helpers successfully coming to Hong Kong through the EA, and the number of foreign domestic helpers successfully recommended by the EA to come to Hong Kong and stay for 6 months in the same employer's with the same employer, and also the switching of jobs. This information could help us differentiate between EAs with good performance and otherwise. The Ministry of Manpower in Singapore has set up such a website to provide information on these intermediaries. I believe that the Hong Kong government can do something like that as well. Now, I should stop here, and I look forward to the government's response to how they can improve the policies on foreign domestic helpers.
Mr. Lam Chun-keung, thank you, Madam Deputy. Foreign domestic helpers come all the way from their home country to work for our households. They take care of our young and the elderly, and it helps to release the potential of our labor force. The rights should be given due protection. For employers, they spend money, time, and efforts to get an FDH. If it is found that the FDH isn't as expected, then there will be a lot of grievance. For employers and FDH, their rights should be protected equally. In recent years, we have seen a lot of complaints from both the employers and employees. It appears that the blame lies on the unscrupulous employment agencies. Employers are saying that some employment agencies have been inducing FDH in job hopping. In 2021, there were 170 such complaints received by the Labor Department. And in fact, some FDH has found that there is an overcharging of commission by the EAs. That is not 10% of the first month's wages, or miscellaneous items have been charged upon different excuses. I agree that we should step up the regulation of FDH employment agencies, like we should disclose the payment items. Now, for the Labor Department, it has been warning EAs that have been breaching the COP or overcharging commissions or engaging in unlicensed operation. But then so far, only 12 such EAs have been blacklisted. Is it really the true picture? If we have got a more transparent and objective rating system for FDH EAs, then both domestic helpers as well as employers can tell which EAs are good ones. And EAs, in order to raise their own ratings, they will be keener in enhancing their service qualities. In the long term, it will have a positive effect on the service quality. In the year 2011, the ILO has come up with Convention 189 in relation to the indecent employment conditions of the domestic helpers. Party members must, in the light of local or domestic laws and regulations, regulate their private employment agencies, like banning employment agencies engaging in exploitation or deception of FDHs. We have not sort of signed this particular ILO convention, but still I think the government should make reference to that to have reasonable safeguarding of the FDH rights. For job hopping, the Immigration Department has a special duties team to deal with that. And then trade unions of foreign domestic helpers have told us that even though the FTs have been exploited or abused, they dare not raise any complaints because they don't want to lose the chance of getting a job in Hong Kong. I think the government should also look into possible exploitation of FTs or abusers. And then if the domestic helper takes the initiative to complain, or if there are reasonable or legitimate reasons, then the government should exercise discretion. The FTs are protected by our employment laws. Some of them are similar to our local employees. Now, when there is a medical examination, irrespective of the outcome, as long as it won't prevent the helper in discharging the duties inherent to the job, and if the employer would not be asked to face unreasonable difficulties to cater for the special needs, then the employee should not be dismissed. In the light of the skills, experience, and training of the foreign domestic helpers, I think we should insist on our requirements. Many FDs are good partners. They would witness the birth, development, and growing up of the young family members. Many of them would take Hong Kong as their second home. So we should achieve harmony between employers and the FDH when we develop our policies. So I submit. Dr. Priscilla Leung. Madam Deputy, I speak in support of Dr. Ann's motion as well as the two proposed amendments. If you have an elderly member, it is a treasure. Now, if you have a good FDH, then you have a treasure at home. It shows that a good foreign domestic helper is important for a household. This is particularly true in that we have 400,000 families getting help from a foreign domestic helper. Whenever we have a get-together, we'll be talking about the difficulty in recruiting a domestic helper and all sorts of problems that we are encountering, in particular for families with very young children. Well, in the papers, we have come across stories that foreign domestic helpers have been physically abused and they have to take their employers to court. But in addition, many employers are also asking counselors to set up groups to protect their rights. In fact, together with a number of employers' associations, we called a press conference a few years ago. They aired their grievance. If you have a newborn baby, it will be easily a matter of tens of thousands of dollars before you can get a foreign domestic helper, and yet the helper may easily leave the job. So we have a big problem here. In the case of Taiwan and Singapore, if the foreign domestic helper leaves the job within a short period of time, there will be a record. And also, they would also talk to the places of origin to prevent job hopping for the sake of making financial gains. For the original motion and the proposed amendments, it is said that we may sort of consider coming up with a rating system for the employment agencies, and we should restrict in our regulation of the EAs. I agree with all such proposals. I think it's high time for us to do some soul searching, in particular for young couples. Now, I have been a victim. I have got the experience having all sorts of FDs making telephone calls, costing me thousands of dollars while I was pregnant. Someone would try to leave and cause problem for us. But today, all my children have grown up, but still, I do understand that our younger generation has special feelings for Filipinos, etc., or Indonesians, because foreign domestic helpers from their countries have been sort of taking care of them from young. Now, for the mothers from such countries, they come to Hong Kong, they take care of our children, but their own children lack motherly love. Now, when such countries have an economic development, then they would stop having this kind of source of income, that is exporting foreign domestic helpers to get earnings. In the past, we used to have highly educated foreign domestic helpers coming here. I think for the past 10 years, I think there has been a change in the picture. Hong Kong is no longer a heaven for the domestic helpers. I think for a long period of time, if we still count on foreign countries for a supply of domestic helpers at a very, very low cost, then it just won't last. I think currently the minimum wage is really too low. I think the consulates general have also talked about this as a problem. Well, in fact, we have got retirees who are still fit and healthy, but then for family chores, I don't think it is regarded as a decent job. I think we should make it more respectful and professional, so that retirees would be interested to work, say on an hourly basis. We can sort of get retirees to take care of the elderly, to provide assistance to new mothers. We have got 35% of our population who are aged 65 or above by the year 2034. We should encourage intergenerational help. I think this is also important for the development of the families in Hong Kong. Mr. Yang Wen-kit, I speak in support of Mr. An Man-yu's motion. Other than the middle class, some lower income households have to get foreign domestic helpers to take care of the young and the elderly, so that the mothers can go out to work. Now, our population is aging. There would only be a growing demand, forever growing demand for FDHs. Some unscrupulous EAs would abuse and exploit the loopholes, and inducing the domestic helpers to borrow money, overcharging commissions and overcharging all sorts of items. And some foreign domestic helpers will go missing, and they will try to compel or urge the employers to dismiss them so as to hop to another job. I think we should have some APIs to expose the malpractices of the EAs. I'm sure employers would welcome that. For our problem, I think it is all because of a lack of regulatory work. We haven't had many changes to the standard employment contracts since 1970s. Yes, we have had the setting up of a special duties team set up under the Immigration Department, and we have the 2018 amendment to the Employment Agency's old regulation. 590 complaints were received against the EAs, and then in another year 396. But respectively, only 10 and 4 EAs have been convicted. And then only a small number of EAs have had their licenses revoked. We have 1,500 FDH EAs. Before the pandemic, we had 400,000 FDHs. I think it's high time for the government to regulate the matter. In Singapore, the FDH policy has always received high praises. In fact, the society has been giving recognition to the industry. And there is a licensing examination for the practitioners. There should be a scoring system, a demerit system, a rating system, so that we can find out who are the good EAs. So I agree with what Dr. An Man-yu has said. That is, we should set up an FDH authority so that it will cover licensing, training, inspection, conviction, etc. I think this authority can receive complaints. This authority can carry out undercover inspection of the EAs, so that EAs cannot stay away from the long arm of justice. And then for the premature termination of contracts, I think we need to have more liaison with the consulates general of the countries of origin. Whoever terminates the contract should be sent back to their home country before coming back for another job. I think we need to amend the law. We should also amend the code of practice so as to close the loopholes for the EAs. Say, for example, the items as well as the maximum amount of payments that a EA can charge a FTH. All such items and price levels should be transparent. We should also provide a sort of financial rating system for the FTH so that they won't borrow excessively, so that we don't have to count on our luck to get a good FTH. We should have a assessment system. The government should assess the skills, including the language skills, and then we can have assurance of the quality of the FTHs. Now, we want to have a list, a white list and a black list, so that we can tell who are good FTHs and who are good EAs. And we should have tax deduction for employment of FTHs. And then we can have released our labor potential. The A4 Alliance has asked for a $60,000 tax deduction from our tax burden. We have proposed this proposal for the FS. We look forward to this being met with in the budget next week.
Mr. Leung Man Kwong. Thank you, Madam Deputy. According to the LWB statistics last year, at its peak, we had more than 400,000 FDH in Hong Kong. These FDH share the household chores, take up household chores in families, especially those with elderly family members or children, so that both couples in the household can work, take up employment. We don't have sufficient daycare places in our homes, so the demand is ever on the rise. Therefore, I agree with Mr. An Man-yi that we should step up regulation of agencies and protect the interests of both FDH and their employers. An employer will have to pay for all the expenses related to the traveling and immigration procedures. And if the employer dismisses the FDH ahead of the maturity of the contract, they will have to pay extra for the return passage, etc. Some agencies are not providing good services. Some are not really knowledgeable about the skills of the FDH. Actually, some agencies were found to have covered up the physical lack of physical fitness of FDH. And many FDH would terminate the contract prematurely and take up another job later. We should therefore regulate the agencies more stringently. I agree with the idea of setting up an FDH authority. In Singapore, their EAs are regulated by law. They have imposed maximum fees and charges on various services. And if they breach the relevant regulations, their licenses will be revoked. And all the agencies must undertake an examination for the license to be issued. In Hong Kong, estate agents and insurance intermediaries have to take examinations. So why not employment agents and their intermediaries? So I hope by stepping up regulation, we can better protect the interests of both. And there should be dedicated information website as proposed in the original motion, and there should be a blacklist of unscrupulous agencies and FDH. And we should provide information such as the number of contracts terminated prematurely by FDH introduced by the agency in question. At present, the agency is providing service only in the process of employment, but after the start of the contract, there may be disputes, but agencies will not be involved in handling the disputes. The employer would just be advised to terminate the contract and hire another one. They will not be involved in any mediation or dispute resolution. So I propose that the agency should be involved in the mediation if there's a dispute, so as to foster long-term relationship between the FDH and her employers. FDH help Hong Kong families, and then we can have more employees joining the workforce. Now that we are recovering from the epidemic, we need to revive the economy. So the A4 Alliance would continue to urge for the introduction of a tax allowance in relation to the hiring of FDH. With this remark, I support the original motion and the amendments. Mr. Edmund Wong. Madam Deputy, Hong Kong is a highly commercialized society. Many couples would continue to work after marriage. So we have a lot of families where both the husband and wife will work, and they will need to hire FDH to care for their elderly family members and children and take care of household chores. In my family, I have an FDH, Judy, who have been working for us for more than 4 decades. That is way before I was born. There was a research paper issued by this council saying that for those women in the age group of 25 to 54, 22% of them are in the workforce. Although this is lower than their male counterparts, but it goes to show that the FDH are instrumental in allowing women in Hong Kong to work. But there are many problems associated with the employment of FDH, such as the FDH that doesn't possess the skills required, and the unscrupulous agencies will overcharge and engage in malpractices. With the epidemic, many families have problems in retaining their employer, their FDH. I've received complaints from many families, and they are saying that this is hiring a competent and skillful FDH is just like winning a lottery. During the epidemic, there are many restrictions in the introduction of FDH, and now that we are recovering from the epidemic, it's high time we conducted a review to strengthen the regulation. I support Mr. NGAN's motion and the amendments introduced by the 2 members. We should put our heads together to see how we can improve the system. For example, how we can improve the standard contract for the employment of FDH and also the code of practice for employment agencies so as to deal with the irregularities we see in the market. At present, the standard contract doesn't provide any standards for physical fitness examination or the eligibility of testing service providers. Some FDH came to Hong Kong, but they were and then found to be pregnant or physically unfit. And hiring another one would mean additional financial burden for the employer. And at present, there's no hard and fast rule that the FDH has to go to their country of origin after terminating their contracts. Many people make use of this loophole. So we should make it a rule that FDH should go to a government-accredited physical examination facility for the medical examination, and also to make sure that the FDH has got a return ticket, and so that when they terminate their employment contracts, they can be repatriated. and we can therefore prevent some FDH from job hopping. We should also revise the code of practice for employment agencies. Fees and charges should be itemized and set out clearly. The refund policies, and also there should be performance of pledge and regulation of fees and charges levied by the agencies. With these remarks, I support the motion and the amendments. Mr. Edward Leung, I speak in support of Mr. Ngan's motion and the amendments moved by the two other members. The employment of FDH has enabled Hong Kong to have a greater workforce, especially this is true for middle-class families. This is an essential service that they need. If we are talking about a working couple who both of them are the professionals, if one of them has to leave employment just so that they can care for family members, there will be a great loss to our economic development. So it's important that we facilitate the employment of FDH. But for these families, hiring a good FDH is just like buying a lottery ticket. You can never tell whether you win or not. Some of the FDH claim to have a lot of skills, or they are competent in certain language, but then in the local language, and when they arrive, things are quite different. And many FDH were prevented from coming to Hong Kong during the epidemic, and the local FDH become very popular and items in commodities in demand. And they would quit their job and go to work for another employer. And the agencies earn their fees by offering employment opportunities to these FDH. So if they change employers, agencies will stand to benefit. In 2021, the Labour Department received 380 complaints against employment agencies. It's found that 62 have violated EOs, and 334 are in breach of the code of practice. But ultimately, only 4 successful prosecutions were initiated. So the present laws and regulations are rather lacking in deterrent effect. And even if the license of the employment agency is revoked, it's very easy to apply for a new license. At present, there's no need for the accreditation of a foreign government before one can set up an EA for FDH. So we should learn from the system introduced for estate agencies. We should set up a FDH authority, which should be vested with power and functions, especially in enforcing the licensing conditions. For example, we should enhance the inspection of the information provided in the application form. The track record and employment history of the FDH should be set out in the information page so that we can avoid hiring unscrupulous ones. DAB wants to set up a regulatory system on FDH policies. This would not just protect the interests of employers, but also those of FDH. We know that there are many criminal cases involving the abuse of FDH. We should also therefore make use of a new mechanism to protect FDH from oppression. Many FDH are part of the families of their employers. So we hope that this new coordination platform would help fostering a better relationship. With these remarks, I support the motion and amendments.
Mr. Chun-keung Paul. Thank you, Madam Deputy. Since the 1970s, Hong Kong started to introduce FDH into Hong Kong, basically for them to take care of the young and the old, so that younger family members could join the workforce to support economic development in Hong Kong. So we must acknowledge the FDH's contribution. We have a large middle class in Hong Kong, and there is a forever keener demand for foreign domestic helpers. They do household chores, they take care of the elderly family members and the chronically ill. And now we have 400,000 foreign domestic helpers in Hong Kong. With this size, there are problems. So it's high time that the policies be reviewed. Because of the epidemic for some time, foreign domestic helpers couldn't come to Hong Kong, and many families were left in the dire straits. And as a result, employment agencies incited foreign domestic helpers to engage in job hopping, affecting many families. Now, the Immigration Department received some 5,800 complaints in this regard, a 200% increase comparing to the previous period. Now, with resumption to normalcy and the Immigration Department's enforcement action, things have become normal again. Still, I think that we should review the foreign domestic helper policies because they directly affect the living of many other people. Now, take job hopping as an example. If an FDH prematurely terminates a contract, then the family will be left in dire straits, and the FDH may also file a claim against the employer for breaching the contract. The other point affecting the employers is about taking out loans. Now, there are no official statistics, but it seems to be a common theme. Some foreign domestic helpers may take out loans to help their family members in the original countries, and when they're unable to repay, debt collectors will knock on the doors of employers. And even some employers have indicated that they received messages from debt collectors about foreign domestic helpers' loans. This has a great this causes a lot of stress among employers. There are also other problems. For example, a mismatch. When the foreign domestic helper was the candidate, she might say she speaks Cantonese, but not so when she arrives in Hong Kong. Now, if you have a business registration certificate and an EA license, together with the accreditation of a foreign consular office, you can start the business as an employment agency without any regulatory oversight. And in fact, the work entails a lot of areas. It should become a profession. And not to mention the legal framework was drawn up in the 1970s is outdated. There are unscrupulous, unbridled EAs engaging in malpractices, and there are also intermediaries engaging in malpractices in the market. Now, I'm concerned that if we establish an authority as a regulator, it may be too costly, and that ultimately the cost will be transferred to employers. All we need is a good regulatory framework to monitor the situation, and there should also be other requirements restricting foreign domestic helpers from taking out loans. Mr. Robert Lee, I thank Dr. An Meng Yu for moving the motion and the amendments so that through improving the policies on foreign domestic helpers, a more proactive approach can be adopted in tackling the foreign domestic helpers' job hopping issues and other issues, then enhancing the protection of the interests of employers and helps. We have over 400,000 foreign domestic helpers working in Hong Kong. There is a keen demand, and they play a very important supporting role for families in Hong Kong because they help perform household chores and protect the young and the old in the take care of the young and the old in the families so as to unleash the potential and allow women to join the workforce. Because of COVID-19, fewer foreign domestic helpers came to Hong Kong for some time, and as a result, the fees required to hire an FDH increase substantially, not to mention job hopping becoming more serious, and the quality of foreign domestic helpers. All these have led to a greater concern on the regulation of FDHs in Hong Kong, and I have 3 suggestions. First, we should step up public education and publicity for foreign domestic helpers to know about the risk of premature termination of contracts and job hopping. Immigration Department should step up liaison and establish channels to explain to foreign domestic helpers about the consequences. For example, if contracts are terminated prematurely without good reason, if a help is unable to explain why she's frequently switching employers, there is a chance that the visa application may not be approved in the future. They will have a limited career prospect. Second, information should be consolidated. The Labor Department at the moment has a dedicated website for employment agencies and another website for foreign domestic helpers. They should be consolidated for employers to get a one-stop service and access to information about foreign domestic helpers. At the same time, there should not be over-regulation of employment agencies and the help, because this will entail escalated costs, and the costs will be transferred to employers. Third, we must enhance the quality of training for foreign domestic helpers. Employment agencies and intermediaries should provide proper training courses to teach foreign domestic helpers the skills of household chores and taking care of the young and the old. More elements should be included, such as the local culture, so that they can have a sense of belonging in Hong Kong. I hope that through these measures we can tackle the existing problems relating to foreign domestic helpers and the agencies. More importantly, we should make Hong Kong an attractive place for foreign domestic helpers. That means a favorable working environment for them, so as to promote the harmony between foreign domestic helpers and their employers. So submit. Mr. Tony Chair. Thank you, Madam Deputy. Foreign domestic helpers are crucial members of many households because they take up household chores and they take care of elderly and children at home. As a result, the employers can rejoin the workforce and earn an income. Improving this stable supply of foreign domestic helpers is important in ensuring harmony and promoting economic development. We have about 400,000 foreign domestic helpers in Hong Kong, accounting for about 10% of the local workforce. The minimum allowable wage is about $4,700 a month. The hourly rate is in fact far below the statutory minimum wage for local workers. However, I rarely hear about complaints from the labor union leaders and members representing the labor sector that we should have fewer foreign domestic helpers, or we should increase the minimum allowable wage to bring it on a par with the statutory minimum wage in Hong Kong, because we all know that this is not pragmatic. Even if we raise the foreign domestic helpers minimum allowable wage, we won't be able to find sufficient hands locally to do the household chores. As a result, some employers will not be able to take up jobs and earn an income for the family. So Dr. NGAN's original motion and the 2 amendments relate to urging the government to comprehensively review and improve the policies on FDHs and protect the interests of both employers and FDHs. I support all of them. Apart from foreign domestic helpers, I think that the government should review the policies on labor importation. Now, according to the labor sector members, labor importation will mean jobs taken away from local workers. This may be true for certain job types, but in some industries, high wages are offered and still they're unable to attract new blood, especially jobs that are shunned by young people. I think that labor should be imported at an appropriate scale for the purpose of promoting economic development and improving people's livelihood in Hong Kong. Foreign domestic helpers is one such example. The other example is care workers in residential care homes for the elderly and the disabled. These are jobs not preferred by locals. But against the backdrop of an aging society in Hong Kong, there is a keener demand for manpower in these areas. COVID-19 have highlighted the shortage, and the staffing ratio requirement will be further tightened for the residential care homes in the future. And I think that we should step up our effort in importing care workers to take better care of our elderly and allowing more people to rejoin the workforce. The construction industry just published a report on manpower projection. It is envisaged that more public and private works projects will come on stream, and it is expected that for the middle-ranking personnel, site supervision staff and technicians in the coming years, Hong Kong will experience a different extent of manpower shortage. And manpower relates to site safety and construction costs, so on and so forth. And manpower shortage will definitely have a bearing. I hope that the government will adopt the same yardstick and take a pragmatic approach in considering importing labor for the construction industry, so as to fulfill what President Xi said on the 1st of July, so that we have a continuous continuous impetus for economic growth, so as to enhance speed, quality, and efficiency of housing production.
Ms. Rebecca Chen, thank you, Madam Deputy. According to the statistics, we had as many as 340,000 foreign domestic helpers in Hong Kong. In other words, we have got 340,000 households getting help from a foreign domestic helper to take care of the young and the elderly. It is important to examine the FDH policies, not just for the sake of the FDH, but also the FDH families. We are also a double income family. I'm grateful to my FDH for taking care of my family and doing the house chores for me. I'm grateful that I have got a very good FDH. But around me, we have got friends that have a different story to tell. And in the media, we have got stories concerning unscrupulous employment agencies. Employers and FDHs have suffered as a result of the unscrupulous practices. EAs vary in their service quality. Of course, I'm pinpointing on those that have malpractices. In the past few years, while we suffered from the pandemic, there was a shortage of FDHs, and some EAs have induced the FDHs to job hop by forcing the employers to quit them, to dismiss them. And FDHs have been advised to ask for double the standard payment, which as a result, the EA can earn more commissions, and then the FDH can also stay in Hong Kong despite a change of employer and can earn more. I think we need a dedicated department. We should also have a rating system for the EAs, so as to protect the interests of both the employers as well as the FDHs. I think other than better regulatory work, we should also make good use of information technology to provide support to the employers and FDHs. We should provide a support website to the employers so that we can have a mobile application so as to provide support and to receive complaints from the employers. For an inexperienced employer, they may unknowingly get the service from a EA which has got a past conviction record. I know that there is a blacklist of EAs with previous convictions, but then is it easily available? I think we should have a rating system concerning EAs that provide service to premature termination of to FTH that have premature termination of contracts. We should also have AI searching engines so that the platform can collate the information received, and then we can have a good scoring system. Employers can make the informed choice and better safeguard the interests. And currently, we have information put together by netizens. It is available on social networking platforms or shared among mothers groups, like a list of things to do and not to do, and taboos, etc. I think we can also learn from them, and then we can make such information available, and we can avoid having conflicts. And then an employer may suspect that FTH may have been borrowing excessively, and the employee may have absconded. Usually employers don't know what to do. In fact, you can just fill out the ID 407E to prove that the employee has already left, and then the EA should be aware that no service can be provided to such a FTH, otherwise it will be a breach of the regulations and it would become liable. Many FTHs in the past have been treated unfairly and in an unfriendly manner. So all the more I should support the motion as well as all the amendments. This is not just to protect the interests of the employers by implementing the proposals in the motion and the amendments, then we can have fair treatment of the FTHs. All the proposals should be considered by the administration. So I spoke. Thank you. Mr. Frankie Yik. Madam Deputy, first of all, I'm grateful to Dr. N for moving this motion, a topic close to the heart of many middle-class families, so that again we can hold a debate on this topic. As Mr. Chun-keung has said, in Hong Kong, approximately 340,000 foreign domestic helpers are working in Hong Kong. For all the time, we have had a shortage of supply of FTHs, but the government has never set up and promulgated any dedicated legislation concerning FTHs, and we just rely on the Labor Department. Many people have said that the policies are biased towards protecting the FTHs rather than protecting the interests of the employers. You may say that the FTHs come to Hong Kong, leaving behind their families at home, and so their basic rights should be safeguarded. For the Liberal Party, of course, we won't object to such an approach. However, you have read many stories in the media. Many of them have had some diseases. They didn't tell us the truth. They came here for the sake of seeking medical help at our public hospitals. But the employers cannot dismiss them. The employers pay for their arrival, and yet they don't get any service from the FTH. They don't even have to take care of the sick FTH. Or the helpers may try to commit mistakes, break down the damage the electrical appliances so as to secure a sort of termination of the contract prematurely, and then they can switch to another job, and the EAs can have lots of business, lots of transactions by encouraging job hopping. The Liberal Party has received some complaints. Many FTH would not want to sort of I know that usually courts will deal with labor disputes involving FTH in a special way. A small number of FTH would try to deceive the employers, saying that they need money for medical expenses or their emergencies back home, wishing the employers to give them money or lend money to them or ask financial companies to lend money to them. They don't have the ability to repay, or they don't plan to repay, and then they abscond right after that. And then when debt collection teams approach and knock on the door of the employers are pestered by such sort of problems. Of course, sometimes FTH may have their own issues, and it is difficult for us to regulate. Mr. Chun-keung has said that we should find ways to prevent FTX borrowing from banks and financial institutions, and employers should be free from the nuisance when the helpers default in their repayment. To many families, helpers are indispensable, and they have been regarded as part of the family. We want to have peace of mind. We hope that we have a good FTX so that we can go out to work without having to worry about that. And we hope that the helper can stay with us for a long time and renew their contracts. However, there are also FTX who have been induced by the unscrupulous EAs to behave in such a way to secure premature termination of contracts. So it is important for us to regulate the performance of the EAs. Finally, I think the Labor and Welfare Bureau, the Labor Department, the Immigration Department, among other departments, must step up your inspection, public education, and publicity so as to make sure that employers and FTH will have their rights and have their rights safeguarded under the law. Thank you. Ms. Eunice Young. Madam Deputy, I support the original motion moved by Dr. An Man-yu. Today, we see that two other members would like to seek an amendment, that is, Mr. Lee Chun-keung and Ms. Judy Chen. I support both members. We have got 340,000 FTH working here. In other words, 340,000 families have employed FTH at home. So it isn't just a matter of the number of FTH. We should also look at the number of families that will be affected, and we need to look at their needs. Many members talked about job hopping and trying to make employers fire them. In the year 2010, 2,833 cases were were rejected in terms of visa application. That's because of job hopping. In the year 2022, for the first quarter, 612 applications have been rejected upon suspicion of job hopping. In other words, the Labor Department and Immigration Department have been collecting intelligence, and we have been telling the employers associations that they can reflect to the Immigration Department and the Labor Department as to the problems that they have encountered in recruiting employees. Well, the channel is there, but then perhaps we should make it more effectively so that complaints can be received and dealt with effectively, whether they are employers or FDH. For Mr. Lee Chun-keung's amendment, it is said that he would like to have the following measures to protect the interests of both employers and FDHs. I need to emphasize the interests of both parties. Just now, a lot has been said about the FDH's rights. I think we should also assist the employers. We should coordinate the measures. Say, for example, if there's job hopping on the part of an FDH, what can be done so that the family needs can be addressed? I think the Labor Department should come up with certain information to help. EA should be asked to help as well. In Dr. An Man-yu's original motion, he talked about setting up a rating system for FDH agencies. It has our support. Have some cases and have reflected the problem to the department. Now, for some FDHs, even back at their home country, they have been told by their EAs that the statutory minimum wage here is 4,000 or so. Now, they have been told that they can only come if they take a pay of $3,000 only. In other words, this is an unscrupulous employment agency intermediary. It's difficult for us to identify them and take action against them. I hope the government can rely on international networking so as to identify the unscrupulous intermediaries. It will tarnish our reputation. It is a matter of exploiting the helpers jeopardizing their rights. Now, some of them are willing to come for $3,000 a month, but can they really accept can they really get $3,000 paid? Sometimes people would not. Some unscrupulous employers may not even pay a single cent, or would not pay the full amount, and then the matter will go to the labor tribunal or the labor department. There may be some reconciliation. Maybe it is a matter of being resolved by being refunded only. But then we need to look at the problem squarely. Please find out whether there are unscrupulous intermediaries that are operating cross-boundary. We want to help the helpers. We would also want to help the employers. We want to safeguard the local employers' interests. So I support Dr. Ng's motion as well as the proposed amendments. Thank you.
Ms. Elizabeth Kwok. Madam Deputy, I have received many complaints from FDH employers. Actually, it's a daily occurrence to me. Whether it's about job hopping or the skills are not as described in the CV, or they may not be able to speak the local language, or may not be able to help in doing the chores required. I've received many complaints very frequently. So over the years, I've been asking the government on how we might deal with such situation. In the last term of government, we had a very vigorous debate with the then Secretary for Labour and Welfare, Dr. Chun-keung. And after the debate, I would receive even more complaints. It seems that the policies that we have are favoring the FDH in a dispute rather than the employer. That's the crux of the matter. The government is burying its head in the sand, opting to choose nothing and sweeping the problems under the carpet instead of taking action. And now Dr. Ngan moved this motion on improving the policy on FDH. I support it, and I also support the amendments put by Ms. Lee Chun-keung and Ms. Judy Chen. This is a document prepared by the DAB, an initiative to improve the policy on FDH. In this document, you can see many suggestions and measures proposed by DAB, which is the labor of people like Dr. Ngan. And we have also collated all the problems that we have encountered over the years, followed by the concrete proposals to make improvements. These proposed solutions are very focused and targeted in nature. When we want to see improvement in the policies on FDH, community comments tend to say that we are not trying to help FDH, or that we are unscrupulous employers. We have 330,000 FDH serving the 330,000 families. I don't have an FDH, but my mom's FDH has served my family for decades, and she's considered part of the family. FDH take care of children, and when the children grow up, in my family, for example, the same FDH is now taking care of my sister's children. We all know that FDH are very important to Hong Kong as a community. Therefore, we want to strengthen protection for both. The interests of FDH are not different from the employer. FDH come to work in Hong Kong, and they can improve the livelihood of their families back in their countries of origin. Mr. Ngan has set out in great detail the relevant suggestions and recommendations. I hope the Secretary would take them on board and implement them. To many middle-class families, hiring an FDH means a huge investment. And if you paying that tens of thousands of dollars in hiring an FDH, and then the FDH will leave in a few weeks' time, that would be a great loss. So therefore, in respect of setting up the FDH authority and reviewing and amending the standard employment contract, well, the right time to do it was yesterday. There's no reason why the government should refuse to do it now. If the government decides not to, please give us a detailed explanation so that we can relay your explanation to FDH employers. We need to see a harmonious relationship between FDH and their employers. With a good system and a good regulation, we can see a more harmonious community in Hong Kong. Reverend Peter Kuhn. Well, Hong Kong started to admit FDH in the 1970s, and many FDH are taking up a significant role in taking care of family members, both young and old. And as a result, women can be released into the labor market and take up employment. So FDH contribute to our economy. We have 330,000 FDH serving many families. With the aging of society, the demand is going to increase over time. At present, the FDH policies are lagging behind the times, and there are shortcomings. We've heard from employers complaints against agencies. There are some unscrupulous FDH agencies, as well as job hopping FDH, and employers are at a disadvantageous position if they want to have their grievances and problems solved. Complaints handled by the Consumer Council can only be confined to issues relating to services rendered. But if the FDH misrepresents her skills or becomes pregnant in the course of their employment, employers have nowhere to turn to address their grievances. FDH has a long-standing problem of borrowing. Under the old regulations, even when the employer discovered that his FDH has borrowed money, it's not a ground for dismissal. And if they are harassed by debt collection agencies, they can only call the police for assistance. And this borrowing problem of FDH is getting more and more serious. There was a background checking service offered by a credit rating agency, which would allow the employer to understand the background of the HD, the credit history, and other details before the employment starts. And so that's something that can be checked to assure the employer it's just like what people would do when they apply for a loan from a bank, and the bank would do similar checks. But there should be a ceiling set for loans taken out by FDH, for example, 2 or 3 times of the monthly salary. The existing policies are not balanced policies. Many agencies are engaging in malpractices. If we look at our neighbors, Singapore, they have a very good system that can protect the interests of both the FDH and the employer, and also the system confers credibility on the work of the agency. So we should improve the EA the regulations and the code of practice for employment agencies, thereby improving the quality of FDH service, and also make sure that the malpractices can be stopped. So I hope the government can deal with these long-standing problems so that FDH can make a better contribution to our community. So I submit. Mr. Doreen Kong, Madam Deputy, I'm grateful to Mr. Yi for moving this motion on improving the policy on FDH. The policy of FDH was introduced in the 1970s. And these FDH have been providing services to a great extent to families with both couples, both of the couples working, and therefore it allows more women to take up employment. FDH has been serving useful and constructive purposes, but alongside we have also seen problems. The administration's policies have not yet been able to move ahead with the times. According to the latest statistics, at present, we have about 400,000 FDH, with the biggest share taken up by the Philippines. In recent years, we have also many Indonesian FDH. Their share is on the rise. So this is one of the factors affecting the FDH market. There should be better regulation of employment agencies of FDH. We should try to improve their rights and employment conditions. So we should have a special scheme for FDH to be imported to care for elderly Hong Kongers living alone. According to the projection, 1/3 of our population will be over the age of 65 in 10 years' time, and there's a greater and greater demand for care. Singleton or the elderly couples without children are rising in number. The aging population has led to a greater demand for care services. And our residential care and residential care homes for the elderly are not able to catch up. In the short term, if we want to improve the RCHE supply, we should import more skilled caregivers. So perhaps we can allow FDH to be involved in caring for the elderly. At one point, the government introduced a voucher scheme for community-based service for the elderly, but the response was not great. Many people have said that the government has not paid attention to the details, and too much reliance was placed on FDH. And there's no continuity, and the involvement of FDH is not easy to implement. The government should clarify the purpose and the development of the service. There should be policies set on the macro scale, and we should properly regulate the service sector for the elderly so that we can introduce FDH to help us cope with the problem. So I would say that the 400,000 FDH represent a huge resource for our manpower pool. We should try to invigorate the market. The government should conduct in-depth studies on how to diversify the duties discharged by FDH. And we should establish a channel to introduce FDH to address the problems associated with an aging community.
Mr. Paul, Chair, Madam Deputy, we do have a broad political spectrum today, especially in this debate. We started with a debate on foreign domestic helpers, and then we move on to talk about care workers. Mr. Tony Chair even talked about manpower for the construction industry. It's all right, but in the interest of time on this topic, I'm not going to recite the contribution made by foreign domestic helpers, overcharging of commission, job hopping, taking out of loans. I think we've all heard the same stories before. I just want to give this observation. I may be quite unique in this regard. In 2022, on the 19th of January, we had another motion, a similar motion, and I mentioned that we should provide more choices. We should, apart from foreign domestic helpers, allow mainland domestic helpers to work in Hong Kong. And as mentioned by other members, many households have elderly members. If we're able to have mainland helpers, we can be politically correct, so to speak, because apart from learning English, we should also learn 普通话. So we should consider allowing the supply of mainland domestic helpers in Hong Kong. Now, I've heard many members speak today. You may be one of the middle class. You may represent your sector. Now, we have employers in different sectors. And every now and then we talked about the foreign domestic helper associations. They talked about different cases, and these associations every now and then may stage rallies and demonstrations. But so far, I haven't heard anybody talk about employment agencies. It seems that nobody represents them. Nobody talks about this issue from their perspective, except to say that there are many unscrupulous EAs, and many members criticize the government for acting slowly. I think in a moment the public officer will be giving us a reply. But anyway, I'd like to provide more perspectives into this issue. This is a complex issue involving many stakeholders. Like as the Chinese saying goes, it's easy to meet up but difficult to live together, especially for those with different language and cultural backgrounds. And we should not limit ourselves to the local situation. Have a wider perspective, because many countries would like to attract foreign domestic helpers to work there as well, especially with the relaxation measures in order to stimulate the economy. Some countries are able to pay up to 10,000 Hong Kong dollars for a foreign domestic helper to work there. Of course, I'm talking about pre-COVID. So there are different factors to consider. I'm looking at some cases, some figures relating to abuse cases, the more serious ones. Some cases have left us aghast about the acts committed by employers, and in some other cases we've heard about job hopping, taking out loans. But we should consider things in perspective. In all fairness, the foreign domestic helper regime in Hong Kong is quite solid. Well, you talk about the merits in the Singapore system, but we're talking about foreign helpers in Singapore, up to 1 million of them working in different trades and fields. That's their background. But in terms of foreign domestic helpers, we have seen decades of their contribution in Hong Kong. And when it comes to job hopping, it seems that despite not having an official blacklist, there are figures kept by the government about premature termination of contracts without justification, and there are ways to handle their applications. So I really agree with a lot of members' suggestions today, but we need to be fair and we need to take different perspectives in considering the issue. We must not go overboard because we already have many obstacles to economic development. We should not do anything further to hamper the economy. Does any other member wish to speak? Dr. MNU, you may now speak on the amendments. Madam Deputy, I thank Mr. Lee Chun-keung and Ms. Judy Chan for their amendments. As Mr. Lee suggests in his amendments, many employers face the issue of foreign domestic helpers taking out loans. This is a complex issue. Very often, the foreign domestic helpers are required to pay referral fees and training fees that are really hefty before they could come to Hong Kong. And foreign domestic helpers sometimes also need to pay for school fees for the children, so on and so forth. Now, of course, it's their choice, but indeed, there are many difficulties facing foreign domestic helpers as well. At the moment, there is nothing in the law that stops a foreign domestic helper from taking out a loan. And there is and the employer cannot withhold the ID document. Now, that is why in my submission, I say that the government should conduct a review and impose a ceiling on the loan amount, say 2 months of the foreign domestic helper's salary, to prevent excessive borrowing, so that employers will not get into trouble for repayment defaults. Now, the amendment also talks about poor performance of foreign domestic helpers, and I mentioned that the DAB's survey included this question. 47% of employers indicated that they are disappointed in the helpers' performance. That is why I suggest that training courses should be provided for foreign domestic helpers to have a better grasp of the local customs and habits, especially when foreign domestic helpers are often required to take care of the young and the old. Dedicated training courses should be provided in this regard. I believe this will provide practical help to a lot of households. Ms. Judy Chan's amendment refers to establishment of a licensing regime for intermediaries or agencies. Now, the DAB is open to this suggestion, but if the authority is to be established with a number of functions, then then the DAB's suggestion should be heeded so that the authority can oversee all these areas. Now, about the scoring system, there should be 4 criteria: attrition rate, job switching, and also the number of years of the EAs in operation, so on and so forth. And scores should be accorded according to the 4 criteria. And this will directly affect the reputation of EAs. We support the 2 amendments. I so submit.
Secretary for Labour and Welfare. Madam Deputy, let me once again thank Dr. MNU for sponsoring the motion debate, as well as Mr. Lee Chun-keung and Ms. Judy Chan for proposing amendments. In addition, altogether 23 members have spoken. Members have come up with valuable suggestions. I take this opportunity to give an overall reply. First of all, Dr. MNU suggested that we should set up a foreign domestic helper authority. Other members who spoke also said that probably it would be a feasible idea. However, if I may sort of look at the details of such a proposal, that is, if we are to set up an FDH authority, I can fully understand the motive or the reasons behind such a proposal. You need to understand that an FDH is different from an estate agent or other sort of jobs. For FDH, we are not talking about licensing regime or regulating a profession. Under Dr. Ng's proposal, the authority is supposed to process and approve an application by FTH to come to Hong Kong. In fact, the power to approve or otherwise rests with the Director of Immigration. If we are to take this function away from the Director of Immigration, then it will be a very complicated issue. For foreign domestic helpers, they can only come upon being given approval by the Director of Immigration. So if we are to take up such a change, then there will be far-reaching effects. And then the authority is supposed to grant a license to the EAs. However, the inspection of EAs, etc., are provided for under the Employment Ordinance. The Labour Department is charged with the duty to deal with the employment agencies. If we are to carve it out from the work of the Labour Department, then it means that we need to get more people to work on it, and we need management staff to oversee the frontline staff working on the ground. So if an authority of such a nature is to be set up and takes care of everything related to FTH, which fall under different portfolios and subject to different laws and regulations, then we're talking about major changes and there will be far-reaching effects. We need to act with the greatest degree of care. For the time being, we don't think that this is the right time to introduce such a major change. Mr. Porches was the last speaker to speak, and he said that, to be frank, if we make comparisons within the region, we have been faring quite well. In fact, if you have noticed, I visited Singapore and the Philippines as my first place, or the first two places to visit upon assuming office. Well, this is all because we have got such a large number of Filipinos working as FTH. We need to have a good relationship with their government to make sure that we have a reliable supply of FTHs. My visit to the Philippines gave me this impression. In the eyes of the Filipino government, since we have got the standard employment contracts, we treat the FTH equally as our local employees, so we've been regarded as the best employer in the region. All the labor rights are applicable to the FTHs, and the Philippines would like to set up a new ministry. Instead of having the labor ministers or the foreign ministers taking care of FTH, they will have a migrant worker ministry. I've talked to them, and they really appreciate the safeguards that the Hong Kong government provide to their helpers, and they appreciate the policies that we've introduced. What we will do is that, as in the past, as far as FTH policies are concerned, we'll continue with our good work, and we will strive to have improvements, like vetting the work visa applications, regulate the employment agencies, safeguard and publicize the rights and interests of the employers as well as the FTHs. And with the setting up of a FTH division under the Labour Department, we are firmly convinced that we have seen an improvement in the service quality of our department, in particular during the pandemic. As a result of the need to battle against the infection, for both the employers as well as FTHs, they are faced with a lot of challenges. For our dedicated division on FTHs, and together with the Immigration Department, we exerted our best efforts to resolve a large number of problems. Currently, we have got a dedicated website so that employers and FTHs will understand our policies. There is also useful information and useful links. Last May, we have introduced the Employers' Corner so that employers get more information so that they can easily understand their obligations and rights. And they can also, through the website, know more about the eligibility and procedures of recruiting at FDH, and they can get the relevant forms. We'll continue to improve our work, and we will step up our publicity. In the debate that went on a moment ago, many members talked about the need to review the standard employment contract. Well, in fact, we have been looking at the issue. We try to see whether there is a need to change the standard employment contract. In the year 2017, there was a change. We introduced a new clause, and that's in relation to the cleaning of outward-facing windows, because at that time there were a number of fatal accidents, foreign domestic helpers falling to their deaths when they were cleaning the windows. So we've introduced a new clause. The employment contract has been with us for a long time. This is an important document. It is important for us to make sure that it will be sort of retained. For the employers, for the FDH, for the employment agencies, any change of the clauses of the document will have far-reaching impacts. We have got 340,000 FDH serving 300,000 families. Families have got different needs. So when we consider whether there is a need to change the terms and conditions of the employment contract, we need to be careful to make sure that we can safeguard the interests and rights of the employers and employees. And there's also room for negotiation so that we can strike the right balance. Within the standard employment contract, it is said that perhaps we should introduce a mandatory requirement for a medical examination. Currently, generally speaking, we don't ask for a pre-employment medical checkup. Employers and FDH do not have to provide a copy of the report of medical examination. In accordance with Clause 17 of the Standard Employment Contract, before they come to Hong Kong, FDH must undergo a medical examination, and the report should be submitted to the prospective employer. Prospective employers can read the certificate of the medical examination, understand about the physical conditions or the health conditions of the FDH, and then decide whether the FDH can discharge the duties as a FDH. If the FDH refuses to undergo a medical examination or refuses to provide a copy of the report, then the employer may refuse to sign the contract with the FDH. Currently, under the Employment Agency Code of Practice, we have attached a sample service agreement listing out items for medical examination for the reference of employers, like chest x-rays and hepatitis B. The Code of Practice mandates that EAs must make sure that the information given to the employers would tally with what is known to them, including the medical examination report. If it is suspected that the job seeker's information is false or incomplete, then the EA has to ask the relevant persons, like the referrers or the overseas partners, to clarify and ask for supplementary information. If EAs breach the COP requirements, the LD may consider revoking or refusing renewal of their licenses. Currently, the LD is reviewing the implementation of the COP, like regulating and combating unscrupulous EAs and whether they are effective. We would also like to collect the views from the job seekers, the employers, as well as the EAs. And we need to find out whether there is room for improvement in terms of the implementation of the COP. We want to listen to the views of the society, and we want to check whether there have been changes in the society. And then we'll try to learn from the experience of previous implementation, and we want to come up with proposals to improve upon the COP. The LD intends to consult the views of a committee under the Labour Advisory Board and will also present a paper to the Manpower Panel of the Legislative Council in relation to the scope of review and also areas which we may want to introduce changes. The LD would actively consider the following. That is, we may ask the EAs to include in the service agreements the amount of money to be collected, in particular payments to be made by employers, and the EAs should sign a service agreement with the employers covering the sample forms or the items contained in the sample forms in order to beef up the safeguards for the employers. In addition, I have noticed that in the debate, many members talked about Dr. An's proposal to introduce a rating system for FDH agencies. As I have said in my opening remarks, through issuing licenses, inspection, prosecution, etc., and investigation, we regulate the EAs and make sure that all the practitioners of the EAs will comply with the law as well as the 40+ requirements under the COP in coming up with professional services. If it is found that there is a breach of the regulations or requirements, the LD will make a record of the offenses as well as the conviction. And in the light of the degree of seriousness, we will mete out the relevant punishments. When we deal with an application for a license, we will check the records of the licensee, the operators, the management, and the employees to make sure that no one who has broken the law will be able to get a permission to run another EA under another name. In order to make it more transparent and open, when it comes to the previous records of the EAs, since 2018, in our dedicated EA portal, we have been systematically disclosing the records of conviction on the part of the EAs for overcharging of commission and unlicensed operation, or those that have their licenses revoked or refused, renewed, rejected. And then there is also a lot of information to facilitate the making of an informed choice. We also provide information concerning the year of first issue of license, the number of branches, and the location of branches of the EAs. Now, employers have different requirements and expectations of employment agencies as well as the FDH that they recommend. It is difficult to come up with objective and fair criteria, so it may not be desirable to have a rating system. It is said that perhaps we should take the replacement rate of FDH as a rating reference point for the EAs, but then FDH may change the employer for different reasons, like immigration on the part of employers or their financial reasons. So the cases were different. If we simply look at that to come up with a rating system and a score, it will not be fair and complete. And FDH may not go to the same EA when there is a change of employer. So we can't simply use the replacement rate or the premature termination rate to judge whether it is a good or a bad EA. It lacks objectivity, it may not be fair, it may be misleading. For job hopping, as I have said in my opening remarks, we take the matter seriously. The Immigration Department has got a special duties team which carefully vet the visa application of the FDH. If there's evidence to show that there is job hopping, then the Immigration Department would firmly deny the application. In fact, we have told you that when compared with 2020, in 2021, there were 9 times more refusal of visa application for suspicion of job hopping. We also mounted joint operations with the Immigration Department after inspecting the facilities. With the easing of the pandemic, the number of FDH in Hong Kong has gradually gone back to 340,000. We are getting fewer job hopping complaints, but we'll still keep an eye on it. In addition, some members, including Mr. Chun-keung, wondered whether we can come up with a blacklist of foreign domestic helpers. On this matter, I want to say that we have to make sure that if we are to introduce such a proposal, we have to make sure that we meet the requirements under the Personal Data Privacy Ordinance. Generally speaking, the information of individuals cannot be disclosed without the consent of the data subject. But still, if a FDH breaks the immigration laws, or if she or he breaches the standard employment contract terms, then usually the visa application will not be entertained. And after rejecting the application from a job hopper, the Immigration Department will keep a record for reference of future applications, so that there will be a stronger deterrent effect to discourage job hopping. Some members suggested that perhaps when it comes to the skills and training of the foreign domestic helpers, we should enhance them. I said in the opening remarks that before they came, they were supposed to have the waterfront working experience, and they should have received some training or assessment. If necessary, an employer may ask the job seeker to provide evidence in the form of documents or supplementary information. Some EAs will also provide training to help foreign domestic helpers to get the necessary skills to adapt to the new duties. Some members are concerned about the excessive borrowing of foreign domestic helpers. We have been publishing leaflets, we have been holding briefing sessions, and we have been handing out leaflets during weekends at places where they lunch together. We also encourage FDX to talk to their employers in a frank manner if they have problems with their financial arrangements or if they need to borrow money. They should avoid excessive borrowing and becoming insolvent. Mr. Lai Dongguo, Dr. Priscilla Leung, among others, have said that they are concerned about the long-term supply of foreign domestic helpers. 56% of them come from the Philippines, 40% from Indonesia. On our part, we have to make sure that the supply will be steady and reliable. Other than the two major sources, we are also actively considering new sources like Cambodia and other countries. But then probably you have observed that we still have the largest number of foreign domestic helpers coming mainly from the Philippines and Indonesia. Despite our publicity, other foreign domestic helpers are less interested in coming to Hong Kong. But then we have an aging population. Our demand for foreign domestic helpers will only increase and not decrease. We'll make sure that we'll still have a steady and reliable supply of foreign domestic helpers. In addition, in the debate, a number of members, including Mr. Lam Guang, Mr. Yang Man Kit, and Mr. Nissi Lam, we should provide tax concessions or tax deductions for FDH-related expenses. I can refer the proposal to the FS. Similar taxation-related proposals should be treated with the greatest degree of prudence. That is, whether there will be an impact on our fiscal health and whether it is fair, and we should strike a balance between their needs as well as the need to maintain fiscal health. We need to look at the details, and we need to look at the implications and what happened to the local employees, and would it become a very cumbersome administrative workload. Mr. President, we'll continue to fine-tune our FDH policies through inspection, law enforcement, education, publicity. We'll safeguard the rights of the employers as well as the FDH so as to enhance an harmonious labor relationship. And then Hong Kong will remain as an attractive place to FDH, and we will strike a balance between the interests of the employers and employees, and we will review the arrangements, and we will take into account the views of the stakeholders. So I spoke.
修正案。
I now call upon Mr. Lee Chun-keung to move an amendment. Mr. President, I move the amendment. I propose a question to you as stated. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of each of the two groups of members present. I declare the amendment passed. Ms. Judy Chan, as Mr. Lee Chun-keung's amendment has been passed, you may move your further amendment. Mr. President, I move my further amendment. I propose a question to you that Ms. Judy Chan's further amendment be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of each of the two groups of members present. I declare the amendment passed. Dr. An-man Yu, you still have 2 minutes, 16 seconds to reply. Then the debate will come to a close. Dr. An-man Yu. Thank you, Mr. President. I thank all members who have spoken to the issue. I am disappointed at the Secretary's reply, however. Many members who have spoken have provided examples of the problems faced by FDH employers. In 2021, the Baptist University published a study showing that the demand for FDH have continued to increase. And in short, the study shows that many households are becoming more reliant on foreign domestic helpers. And it has to do with the birth rate in Hong Kong. If a couple is able to hire a foreign domestic helper, then they will be 43.3% will be willing to have another child, more than the 29.9% otherwise. I hope that improving the policies on foreign domestic helpers will help increase birth rate in Hong Kong, because it touches on welfare, it touches on population policies as well, as foreign domestic helpers take care of the young and the old, and we also need to protect the interests of both employers and foreign domestic helpers. It's an important public policy in Hong Kong. I put the question to you, that is Dr. An-man Yu's motion as amended by Mr. Lee Chun-keung and Ms. Judy Chan be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of each of the two groups of members present. I declare the motion as amended passed.
Members' motion with no legislative effect. Professor